Hello, inventors. My name is Karima Gulick, patent and trademark attorney, and today we're going to discuss the pitfalls. What happens if you don't file that application for your brand? A few things, right? So, worst case scenario is someone else starts using your mark in another state. Now, you have with trademarks, you get some common law rights. So, basically, you're getting rights for using that mark. However, those common law rights are geographically limited. So the example that I gave before is if I start a restaurant in LA named Flowers, I can stop others because now I have geographically limited rights and I have common law rights to use that word flowers for restaurant. However, if someone starts using that mark in New York, for example, I can't stop someone from starting a restaurant under the word flowers or under the mark flowers in New York. So even though you get some rights, these rights are limited. Other pitfall or worst case scenario that can happen is I started that restaurant, we'll go with the restaurants under Flowers in Los Angeles. I wait for a few years now that I have the funds to actually file and register my mark. I go and register only to find out that someone else has filed for an application before me and have a trademark federally registered for Flowers under restaurants, and I didn't. So what can I do? You can try to cancel their mark for priority. However, if you don't have that federal registration, your priority is going to be geographically limited. You can reach out, try to get some consent with them or some sort of agreement with that party, but it gets a lot more expensive and a lot more difficult to protect your right when it comes to that mark in that geographical region. I hope this helps. If you have any questions, comments, or concerns, please make sure to drop them below. If you have any other topics that you'd like us to cover, let me know. Until next time.